They fined me $89,000 for painting my front door purple. Not bright purple. Not neon. Lavender. A color they'd approved in writing 3 years earlier. When I refused to repaint it beige, the HOA president tried to foreclose on my house. She filed a lien, hired lawyers, and told my neighbors I was destroying property values. She had no idea I'd spent 15 years as a paralegal. By the time I was done, the HOA president was facing criminal charges, the board was dissolved, and 283 families got to paint their doors whatever color they wanted. Let me show you exactly how it happened. My name's Jennifer Acosta. I'm 42, divorced, mom to 2 teenage boys. I'm an immigration paralegal, which means I spend my days reading regulations that would put most people to sleep. I live in Riverside Glen, a planned community outside Phoenix. 1,800 square feet, 3 bedrooms, and a monthly HOA fee of $195. Nothing special about me except one thing: I don't quit when someone's wrong. In March 2021, I decided to repaint my front door. The builder's beige had faded to this sad, chalky color after 8 Arizona summers. I wanted something cheerful. Something that made me smile when I came home from 12-hour days dealing with broken immigration cases. I found this beautiful lavender color. Soft, elegant, not loud. I checked the HOA's architectural guidelines, which listed 47 pre-approved exterior colors. Lavender Mist, Sherwin-Williams 6554, was number 31 on the list. I submitted my architectural review request on March 8. Included paint swatches, the color name, and a section of the guidelines showing it was pre-approved. I didn't need approval for pre-approved colors, but I submitted it anyway to be safe. March 22, I got a response letter. Your request to paint your front door Lavender Mist, SW6554, has been reviewed and approved. Please complete the work within 90 days. Sincerely, Carol Dennison, Architectural Review Committee Chair. I kept that letter. I kept everything. April 3, a Saturday, I painted the door. My sons helped. It took 3 hours and cost $47 in paint and supplies. The door looked beautiful. Neighbors walking by complimented it. One woman asked for the color name so she could paint hers the same shade. Life was good for exactly 11 days. April 14, I found a letter in my mailbox. Riverside Glen Homeowners Association letterhead. I opened it standing at my kitchen counter. Dear Ms. Acosta, it has come to our attention that your front door has been painted an unapproved color in violation of Section 47 of the CC&RS. You have 14 days to remedy this violation by repainting the door an approved neutral color. Failure to comply will result in fines of $50 per day. Sincerely, Carol Dennison, HOA President. I read it twice. Then I pulled out my copy of the approval letter dated March 22. Same signature. Carol Dennison. Same title, though now she was HOA President instead of just Committee Chair. I called the HOA management company, Sun Valley Property Management. The woman who answered sounded bored. I received a violation notice, but I have written approval for this color. Let me pull up your account. Typing sounds. Yes, I see the violation. Front door painted unapproved purple. It's not purple. It's lavender. And it's pre-approved. I have the approval letter. Ma'am, if you received a violation, you need to remedy it or attend the next board meeting to dispute it. When's the next meeting? May 12, 7 p.m., at the community center. I marked my calendar. April 28, I got a second letter. The 14-day period had expired. I was now being fined $50 per day, retroactive to April 14. That was $700 already, with $50 adding every day I didn't comply. I called Sun Valley again. Different person, same board tone. I'm being fined for a door that was approved in writing. Do you have proof of approval? Yes. A letter from Carol Dennison dated March 22. You'll need to present that at the board meeting. Can I send it now? Board meetings are the proper venue for disputes. I hung up and did something I'd learned from 15 years of paralegal work. I started a binder. Chronological documentation of everything. Approval letter, violation notices, photos of my door, photos of the guidelines showing Lavender was pre-approved, screenshots of my payment confirmation for the architectural review fee. If this was going to be a fight, I'd fight with paper. May 12, 7 p.m., I walked into the Riverside Glen Community Center with my binder. The room was set up like a courtroom. Board members at a table in front, folding chairs for residents. Maybe 15 people in attendance, most of them elderly retirees. Carol Dennison sat at the center of the table. She was about 60, with that helmet hair that doesn't move in wind, wearing a blazer despite the Arizona heat. She had this energy of someone who'd finally gotten power after a lifetime of being ignored. To her left sat Martin Fletcher, treasurer, 70-something, constantly checking his phone. To her right, Diane Park, secretary, mid-50s, taking notes like she was recording history. Carol banged a gavel. Actual gavel. Meeting is called to order. First item, violations review. She went through 3 cases before mine. A guy with a basketball hoop mounted above his garage. A woman whose tree branches extended over her fence line by 6 inches. A family whose house numbers were non-regulation font. Each person tried to explain. Carol denied every appeal with the same phrase, rules are rules. Then she called my name. I stood, holding my binder. Jennifer Acosta, 4782, Desert Willow Drive, regarding the front door violation. Carol didn't look up. You painted your door purple in violation of Section 47. Do you have anything to say? Yes. I have written approval from you dated March 22. I pulled out the letter, walked to the table, handed her a copy. Carol glanced at it. This letter is in error. I'm sorry? The color was mistakenly approved. Lavender is not appropriate for Riverside Glen's aesthetic standards. I felt my face get hot. It's on the pre-approved list. Number 31 inch. She opened a binder of her own. That list is outdated. The board voted to remove lavender from the approved colors in February. I submitted my request in March. After you'd supposedly voted. The guidelines weren't updated on the website yet. But the vote is in the minutes. Can I see those minutes? They're for board members only. Martin Fletcher spoke for the first time. Carol, if we approved it, we should probably. The approval was in error, Carol interrupted. The homeowner needs to remedy the violation. I kept my voice level. So you're saying you approved a color, I painted my door in good faith, and now I owe $50 a day because you made a mistake? Rules are rules. You have 14 more days to repaint. Fines will continue to accrue until you comply. This is insane. Carol banged her gavel. Next item. I walked out with my binder and a phone full of recording. Arizona is a one-party consent state. I'd recorded everything. By May 26, my fine was $2,100. I hadn't repainted the door. June 9, I received a notice of intent to lien. If I didn't pay $2,850, the fine had grown, plus a $500 administrative fee, they'd place a lien on my house. June 23, they filed the lien. It showed up on my title when I checked online. $3,350. July 1, they added attorney fees. $5,200 total. I couldn't refinance. Couldn't sell. Couldn't do anything with a lien on my house. July 8, I got a letter from a law firm, Becker & Ross, representing Riverside Glen HOA. It informed me that if I didn't pay $5,200 within 30 days, they'd initiate foreclosure proceedings. Over a lavender door I'd been approved to paint. That's when I stopped being scared and started being angry. I spent the next 3 weeks living in the Arizona State Legislature's website, reading HOA law. Arizona Revised Statutes Title 33, Chapter 16. I read every section, every subsection, every footnote. And I found something beautiful. Arizona law requires HOAs to follow their own governing documents. If they don't, any action they take is void. Not just invalid, void, as if it never happened. I also found that Arizona law requires HOA boards to act in good faith. Approving something in writing, then fining you for it, is literally the legal definition of bad faith. But the best part? Arizona allows homeowners to recover attorney fees if they win an HOA dispute. I called a real estate attorney named Robert Mendez. His consultation was $300. I paid it with a credit card. I explained everything. Showed him my binder. Robert read through it, and I watched his face change from professional interest to genuine excitement. Jennifer, this is the clearest case of HOA bad faith I've seen in 20 years. Can we beat them? We can destroy them. August 5, Robert filed a lawsuit against Riverside Glen HOA, Carol Dennison personally, and Sun Valley Property Management. We sued for declaratory relief, asking the court to declare the lien invalid. Violation of Arizona HOA statutes. Bad faith enforcement. Intentional infliction of emotional distress. Attorney's fees. We also filed an emergency motion to remove the lien so I could refinance. The hearing was August 20th. Carol showed up with the HOA's attorney, a guy named Philip Garrett who looked like he'd rather be anywhere else. Robert presented our case in 15 minutes, approval letter, violation notice, timeline, recordings of the board meeting. The judge, Angela Ramirez, yes, same last name as me, no relation, listened without interrupting. When Robert finished, she looked at Garrett. Counselor, did the HOA approve this color in writing? Garrett stood. Your Honor, the approval was issued in error. The board had voted to remove Lavender from. I didn't ask about the vote. I asked if they approved it in writing. Yes, but. And then they fined her for doing what they approved? The approval was mistaken. Judge Ramirez closed her folder. Gentlemen, and Ms. Acosta, this is not complicated. The HOA gave written approval. Ms. Acosta relied on that approval. The HOA cannot now punish her for their own mistake. The lien is void. I'm ordering the HOA to remove it within 48 hours and to reimburse Ms. Acosta for any title search fees or refinancing costs she incurred. Carol stood up. Your Honor, we have standards in our community. Mrs. Dennison, you are not an attorney. Please sit down. Carol sat. Her face had gone red. The judge continued. This case will proceed to trial on the remaining claims. I strongly encourage the parties to settle. This HOA's behavior is troubling. We walked out of the courthouse. Carol and Garrett rushed past us without making eye contact. Robert turned to me. Want to settle or go for the throat? What happens if we go for the throat? We expose every violation they've committed. And I promise you, if Carol runs this HOA the way she ran your case, we'll find plenty. Let's dig. Over the next 6 weeks, I did something I'd become very good at as a paralegal. I read documents. Every HOA board meeting minute for the past 3 years. Every violation notice. Every architectural approval. And I found a gold mine. Carol Dennison had approved 43 architectural requests in 2020 to 2021. Of those 43, she'd later issued violations for 17 of them. Not just mine. 17 homeowners had been approved, complied, then fined. The pattern was clear: if Carol didn't like you, or if you'd voted against her in a board election, or if you'd questioned her at a meeting, your approved project became a violation. There was more. Carol had a white picket fence around her backyard. According to Section 49 of the CC&RS, all fences had to be natural wood tone or neutral beige. White wasn't listed. She'd never submitted an architectural request for it. She'd just installed it. Her next-door neighbor, an elderly man named Mr. Chen, had submitted a request for a white fence in 2019. Carol had denied it, citing the same Section 49. Then there was the money. I requested financial records, which Arizona law says HOA members can access. The HOA tried to refuse. Robert filed a motion. The judge ordered them to comply. When we got the records, we found $47,000 in administrative expenses paid to Sun Valley Property Management for services never rendered. Invoices for community improvement projects that didn't exist. Checks written to vendors that weren't real companies. Robert hired a forensic accountant. 2 weeks later, she gave us a report. At least $85,000 in HOA funds had been misappropriated over 3 years. We amended our lawsuit to include fraud, breach of fiduciary duty, and embezzlement. September 30th, Carol Dennison resigned from the HOA board. She sent a one-sentence email, "Due to personal reasons, I resign effective immediately." Sun Valley Property Management terminated their contract with Riverside Glen HOA the same day. October 12th, the Arizona Attorney General's office contacted me. They'd received our court filings and wanted to investigate. I gave them everything. November 8th, Carol Dennison was indicted on 6 counts of fraud and embezzlement. But I wasn't done. November 15th, I called for an emergency HOA meeting. Under Arizona law, 25% of homeowners can call one. I got 87 signatures, about 30% of the community. The meeting was November 22nd. Over 200 people showed up. The community center was packed. People standing in the back, sitting on the floor. I stood at the front with a PowerPoint presentation. For the past 7 months, I've been fighting the HOA over a lavender door. But this isn't about my door. It's about how this HOA has been run. I showed them everything. The 17 homeowners who'd been approved then fined. The misappropriated funds. The favoritism. The retaliation. I'm proposing 3 things. First, we vote to remove the remaining board members and hold new elections tonight. Second, we vote to amend our CC and RS to limit the board's power and require financial audits. Third, we vote to reduce our monthly fees from $195 to $95 until we rebuild trust and transparency. The vote was unanimous. By midnight, Riverside Glen had a new 5-person board. A retired accountant became treasurer. A teacher became secretary. A software engineer became president. I didn't run. I'd done my part. December 2021, the new board sent a letter to every homeowner. The previous board violated your trust and misused your money. We're implementing new rules, no architectural requests required for pre-approved colors. Board meetings will be recorded and posted online. Financial statements will be published monthly. Any violation must be issued with photographic evidence and a specific CCNR citation. If you were fined under the previous board, submit an appeal. We're reviewing every case. They reversed 31 violations, including mine. Refunded over $40,000 in improper fines. January 2022, my lawsuit settled. The HOA's insurance paid me $127,000 for emotional distress, legal fees, and damages. I used $25,000 to set up a legal defense fund for any Riverside Glen resident fighting an HOA dispute. Carol Dennison pleaded guilty to fraud in March 2022. She was sentenced to 18 months probation, ordered to repay $85,000, and banned from serving on any HOA board in Arizona. Today, Riverside Glen is different. People paint their doors whatever color they want, within the 47 pre-approved options, of course. But nobody gets approved then fined. Nobody gets retaliated against for speaking up. Last week, I drove through the neighborhood. I counted 23 different door colors. Lavender, sage green, navy blue, even one bright red. My door is still lavender. My sons are in college now. They tell their friends about the time their mom took down an HOA empire over a paint color. But here's what I want you to understand, this wasn't about a door. It was about someone with a little bit of power who used it to hurt people because she could. And it was about documentation. I kept every letter, every email, every receipt. I recorded meetings. I read the bylaws until I knew them better than the board did. When they tried to bury me in paperwork, I buried them back. So here's my question for you. Have you ever dealt with an HOA that abused its power? Drop your story in the comments. Let's build a library of how regular people beat corrupt systems. And if you're fighting your HOA right now, here's what I learned. First, read your CC and RS. All of them. Boring as hell, but crucial. Second, keep everything. Every letter, every email, every approval, every denial. Third, know your state laws. Most states have HOA statutes that protect homeowners. Use them. Fourth, don't be afraid. They only have the power you give them. And finally, remember, they're counting on you to give up. Don't. If this story helped you, hit that subscribe button. Because I've got more stories like this. Stories about people who refuse to quit. Stories with receipts. Next week, HOA tried to ban my Ring doorbell. So I found the law that made them install 50 more. See you then. And remember, keep your documents. All of them.